The stage is set for yet another legal showdown at the Supreme Court after Attorney General Paul Kihara Kariuki and the electoral body IEBC filed notices of appeal contesting last month's appellate court's judgment stopping the BBI reggae. The AG has listed 8 grounds for appeal, among them the applicability of the basic structure doctrine, the sequence to be followed while amending the constitution, and the president's authority to initiate changes to the country's supreme law. And as Francis Gashuri reports, IEBC is seeking the Supreme Court's clarity on the Commission's composition and quorum.
The BBI row is headed all the way to the highest court in the land after 2 losses for proponents of constitutional amendments at the High Court and Court of Appeal. Attorney General Paul Kihara Kariuki, in a notice of appeal filed by Solicitor General Ken Ogeto, wants the Supreme Court to overturn the verdict rendered by appellate judges declaring the BBI process unconstitutional, null and void. Kariuki listed 8 grounds for appeal, among them applicability of the basic structure doctrine in Kenya and whether it limits the amendment power through popular initiative. He also wants the country's top judges, led by Chief Justice Martha Koome, to pronounce themselves on whether amendment of the Constitution through popular initiative can only be conducted through the primary constituent power in a sequential process comprising civic education, public participation, constituent assembly debate, and ultimately a referendum, as outlined by the 7-judge Court of Appeal bench.
We have the firm view that Chapter 16 of the Constitution provides sufficient safeguards and that it is not necessary to import foreign doctrines into the country in a situation where those safeguards are sufficient.
The AG also wants the Supreme Court to annul the Court of Appeal decision that civil proceedings can be instituted against President Uhuru Kenyatta during his term of office with respect to anything done or not done contrary to the Constitution. He also wants the judges to determine if President Kenyatta could initiate the process of amending the Constitution and whether the BBI process violated the Constitution as declared by the Court of Appeal bench.
In acknowledging this plain and in spirit of fact, one does not thereby curtail the president's enjoyment, one might even say deployment of his personal or political rights. All it means is that the space upon which he elected to exercise his rights is reserved for ordinary citizens, the common populace of the Republic of Kenya, and it is not open to the president. It is out of bounds to him.
We are not persuaded that the president cannot initiate a constitutional process, although we also argue that in this case, it wasn't really the president that initiated this process. This process was initiated by the BBI promoters, and on that, we find that the court has erred.
A BBI proposal on creation and allocation of 70 new constituencies, ostensibly to enhance equality of vote and equity in sharing of the national cake, was also declared unconstitutional by the Court of Appeal judges, a verdict Kariuki wants overturned.
The IEBC was not correct when it embarked on the business of verifying the BBI signatures.
The electoral body IEBC has also moved to the Supreme Court, seeking clarity on the question of its composition, the minimum number of commissioners required to transact business, and its mandate in verification of signatures submitted in support of a proposal to amend the Constitution and the entire process of a popular initiative. The Chief Justice, who is also President of the Supreme Court, expected to issue guidelines on the Supreme BBI appeal. Francis Gashuri, Citizen TV.